I have a pretty large base of subscribers and students, and I'm always reluctant to raise people's expectations unrealistically. So I've been hearing for months and months about this stuff that people are winning lawsuits against lenders that are trying to foreclose on their houses, and that they're raising a defense of produce the note. You don't have a copy of the note, or you don't have a valid assignment of the mortgage. So we call this the produce the note, no valid assignment defense against foreclosure. And I was very, very skeptical about this, and I've investigated it several times. And I don't know, I never really felt convinced that it was something I wanted to bring up to you. But recently I realized that actually there was something to this. I investigated it more fully, and I did an interview with a very prominent Florida attorney. He told me that he's got 200 litigants. He has 200 clients, and all of them are defendants in a foreclosure action, because in Florida there's a judicial foreclosure process, meaning that the lender has to file a lawsuit against you, and that's how the foreclosure proceeds. The mortgage is a security for the loan, but they have to file a lawsuit in order to foreclose on the security. So there's a court process in foreclosures called judicial foreclosure, as opposed to somewhere like California or Nevada, where there's non-judicial foreclosure, where the trustee sale is a private sale, basically, according to certain rules, and there's a statutory requirements, but foreclosure in California, Nevada, and many other states is non-judicial. It's outside of the courts. So in Florida, as in other states like Illinois, New York, there's a judicial foreclosure process. So this lawyer, his name is Chip Parker, he told me that he's got about 200 clients, that he has yet to lose a single foreclosure defense. So all of them are staying in their homes. None of them have lost their homes, not one. And what they're doing is he's filing papers for them, defending their foreclosure based on the fact that the lender doesn't have the note, or the assignment is not valid. So the lender then at that point, they've already brought the lawsuit, and they're supposed to already have their ducks in a row. They're supposed to have the note, they're supposed to have an assignment before they file a foreclosure action. But they don't, because about maybe 99 out of 100 loans are originated. The loan mortgage bank, or the bank that originated the mortgage, they have the note. And then the loan got sold off to some big party on Wall Street or in London or whatever, and the note stayed with the original bank that created the loan. So the note is not with the loan, and the people bringing the lawsuit, the company that's servicing the loans, they don't have the note either. And if you don't have the note, you can't prove that you have a right to sue the defendant, that you have a right to the foreclosure action. So at that point, the courts have to dismiss this lawsuit. And there's a lot of papers that go back and forth, a lot of briefs. There's all kinds of things. It's not simple. There's a lot of complexity, and this is very technical. But the fact is that in exchange for some attorney's fees, Mr. Parker has been allowing people to stay in their homes. They're not losing their homes. Now, what's going to happen ultimately is, I don't think that this ultimately is going to keep people in their house. I think that it's going to allow them to settle with the lender. Because if the lender's brought the lawsuit, and the lawsuit has been brought without having the note, without the assignment, then they've done something that's wrong, and there's some liability on their part. And they're not supposed to bring a lawsuit like that in the first place, apparently. So they've done wrong, and the homeowner sort of has an advantage now. And so that kind of puts people in a more equal position with respect to each other, the lender and the homeowner. So this has been, I think, a worthwhile endeavor. Now, you're not going to get away from doing this just free. I mean, you're going to have to pay a lawyer to file papers, and it's complex. And I don't think you can do this yourself. It just doesn't sound like it's that easy to me. So you're going to have someone do it for you. So that means that you are going to be paying attorney's fees. Now, it's true you're not going to be paying on your mortgage during this time, so you're going to save a lot of money, but you are going to be paying attorney's fees. In a sense, it's like the TILA. I did a course on the TILA violations. TILA secrets, Truth in Lending Act secrets. It's very similar. If there's TILA violations, you're going to have to pay a lawyer to pursue an action against the lender, and you may be able to not make your mortgage payments for quite a while, but you're going to be paying the lawyer. So it's true that you'll pay the lawyer probably a lot less than you would be paying in mortgage payments, but it's not like it's just totally a win situation. Now, there are those people that feel that this is all wrong and that people should be bringing these suits, that if you got a mortgage you can't handle, you shouldn't be able to just like not pay on it just because of some technical violations of the law. I'm not going to address that here. I think that as long as it's ethical and moral, everybody has their own ideas, I think it's fine. I don't have a problem with this. But I'm just concerned about getting people's hopes up that this is going to just let them stay in their home indefinitely. I think at some point you're going to have to do something about this. If you are involved in one of these lawsuits, they're going to produce the note. They're going to, they're going to get you out of your house. You're not going to be able to stay and not pay. I think you could settle with them. You could get a much more favorable loan modification, or you could get a much more favorable short sale disposition, like waiver of the deficiency judgment. There's a lot of things you could get as far as concessions go, but it's not going to mean that you're going to be able to stay and the loan's going to go away. Okay, I just don't see that happening. But I do see it as worthwhile. So I am going to be providing the interview that I did with Chip, because there's very valuable information in it. And if you're not on my list already, you're going to want to get on my list here, because you're going to get stuff every day from me that's very valuable. If you're watching this on YouTube, go to mortgagereliefformula.com and make sure you see some of the videos and all the information I have in there. A tremendous number of articles and information on foreclosure and debt relief and settling credit cards and selling your house in 9 days and all that. And I hope this has been helpful for you. It's right now applicable to anybody in a state that uses mortgages, judicial foreclosure. It's not applicable so much in a state like California or Nevada, which uses non-judicial or trustee sale foreclosure. There are possible avenues that you could do if you're in those states, but not nearly the same degree as there are in states like Florida that rely primarily on judicial foreclosure. Richard Geller, I will talk with you soon. Thank you.